Good morning, everyone. I am Guimbaleña from BES HM3A, and for today, I will discuss the Chapter 4, which is the Law on Partnership and Corporation. Learning objectives. Differentiate the serious kinds of partnership and corporations and responsibilities of partners and incorporation. Identify the requirements in the formation and dissolution partnerships and corporation. Topic outline. First, introduction. Second, law of partnership. Next is the essential requisites of a partner. Next, advantage and disadvantage of forming a partnership. Classification of partnership. Forms of partnership. Obligations of the partner. Dissolution of winding up of a partnership, order of liquidations for a general partnership, order of liquidations for a limited partnership, law on corporation, kinds of corporation, advantage and disadvantage of a corporate organization, and corporate liquidation. Law on partnership. Article 1767. By the contract of partnership, two or more persons bind themselves to contribute money, property, or industry to a common fund with the intentions of dividing the profit among themselves. So this Article 1767 of the Civil Code of the Philippines defines as a partnership as a contract where two or more persons agree to contribute money, property, or industry to a common fund with a goal of sharing profits among themselves. The partnership creates a mutual obligation among partners. It is not purely for charity. There must be an intention to earn and divide profits. It differs from a corporation because it is based on a mutual agreement rather than a separate legal entity, or though some partnerships may be registered. A partnership is an association of two or more persons to carry on as co-owners of a business for profit. A definition of a partnership does not include religious associations, conjugal partnerships, and other of a similar nature, because a partnership as defined by law refer only to associations, the purpose of which is to obtain profits to be distributed among the partners. Next is the essential requisites for a partnership. An agreement to contribute money, property, industry to a common fund. This is complied with. First is each of the partners obliged to bring something to partnership, and second, that which is both become common party. And then to divide profits among themselves. This complied with. First is partnership is established to obtain profits. Second, profit must be common to all the parties. And third, profit or loss must be divided among the partners. Next is advantages of forming a partnership. First is easy to form. Second, improved growth possibilities. Third, freedom from bureaucracy. Next is disadvantages of forming a partnership. First is instability. Second, difficulty in obtaining large sums of capital. Third, firm is tied to act on judgment of one partners as agent. Last is difficulty in serving partnership ties. Next is classification of partnership. First, according to subject matter, there are two: the universal partnership, and the second is particular partnership. Universal partnership. A partnership where all of the partners contribute all of their properties to the common fund and speaks of no particular purpose or subject matter as long as the purpose in Making a partnership is obtaining profits and is not contrary to law, morals, public orders, and public policy. Also, a universal partnership is a broad type of partnership where the partners contribute all their present and future assets, profits, and efforts toward a common purpose. This type of partnership can be further classified into two: the universal partnership of property and the universal partnership of profits. So the universal partners of property is the partners contribute all properties they own to the partnership. This includes both present and future assets. The result is that all assets become common property among the partners. For the universal partnership of profits, so these partners agree to share only the profits they will earn during the partnership. Also, each partner retains ownership of their separate property, and only the income or benefits from the properties and businesses activities are shared. Next is the particular partnership. A particular partnership has for its object to terminate things, their use or fruits, or a specific undertaking or the exercise of a profession or vocation. So a particular partnership is a partnership that is formed for a specific business or project. It has a more limited scope compared to a universal partnership. It can involve a single specific transaction or venture, a specific type of business activity, a limited duration. For example, for that is the two engineers from a partnership to construct a bridge. Once the project is completed, the partnership dissolves. Second classification of partnership is according to liability. So there are two: a general partnership and limited partnership. General partnership is composed of general partners where liabilities extend to their personal properties. Second is the limited partnership. Usually attaches the word L plus T or limited at the end of the company name. One formed by two or more persons having as members one or more general partners and one or more limited partners, where the liability of the latter to third persons is limited to their capital contribution. Third classifications of partnership is the according to duration. A partnership for a fixed term. This is one which the term of its existence has been agreed upon expressly, or as when there is a definite period, or implied as when a particular enterprises or transactions is undertaken. Next is forms of partnership. A partnership can be in any form of event if not recorded at the Office of the Securities and Exchange Commission, except when it is stipulated, when immovable property or real rights are contributed, which case there must be a public instruments to which is attached an inventory for the immovable properties and signed by the parties, otherwise the partnership is void. In case of limited partnership, the party must sign and swear to a certificate which shall state, among others, the name of the partnership, adding the word limited, and the character of the business. File for record the certificate in the Office of the Securities and Exchange Commission. Next is the obligations of the partners. First, where the contribution is money or property. If a partner promises into contribution money during the celebrations of the contract, and he fails to do so, he shall pay the interest and damage from the time he should have complied without need of any demand. Next is where contribution is industry. An industrial partner or a particular who merely contributed industry or service to the common fund cannot engage in business for himself unless the partnership expressly permits him to do so, and if he should fail to do so, the capitalist partners may either exclude him from the firm or avail themselves of the benefits which he may have obtained in violations of his provision, which arise to damage in either case. Obligations of the capitalist partner. A capitalist partner or a partner who contributed money and property to the common fund is prohibited from engaging in a business in competition with the partnership, unless there is a stipulation to the contrary. Otherwise, all profits of such partner belong to the partnership, and all losses shall be for his account. Next is the responsibilities between partnership and partner. The partnership shall be responsible to every partner for the amounts he may have disbursed on behalf of the partnership. Next, sharing of profit and loss among partners. The distribution of profits and losses shall be conformity with the agreement. Next is the property rights of a partner. A partner cannot assign his right with respect to the specific partnership, property for the partner's individual debts, or for legal support. Next is the liability of individual partners to third partners. Partners, including industrial partners, are liable to data with all their properties for contracts with third persons provided. Liability of limited partner. A limited partner is liable as a general. Dissolution and winding up of a partnership. Article 1830. Dissolution is caused without violations of the agreement between the partners, by the termination of the definite term or particular undertaking specified in the agreement, by the express will of any partner who must act in good faith when no definite term or particular undertaking is specified, by the express will of the partners who have not assigned their interests or suffered them to be charged for their separate debts, either before or after the terminations of any specified term or particular undertaking, by the expulsion of any partner for the business in accordance with such power confirmed by the agreement between the partners, in contravention of the agreement between the partners where the circumstances do not prevent a dissolution under any other provision of this article, may be express will of any partner at the time, by any event which makes it unlawful for the business of the partnership be carried on for the members to carry it in partnership. With a specified thing a partner had promised to contribute to the partnership perish before the delivery in any case by the loss of the thing, when the partner who contributed it, having received the ownership therefore, has only transferred to the partnership, and by the death of any partner, by the insolvency of any partner of the partnership, by the civil interdictions of any partner, and by decree of court under the following article 1700 and 1701. In Article 1831, on applications by or for a partner, the court shall decree a dissolution wherever a partner has been declared insane in any judicial proceeding or is shown to be an unsound mind. A partner becomes in any other way incapable of performing his part of the partner's contract, and a partner has been guilty of such conduct attempts to affect prejudicially the carrying one of the business. A partner persistently commits breach of the partnership agreement or otherwise so conduct himself in matters relating to the partnership business that it's not reasonably practicable to carry on the business in partnership with him, and the business of the partnership can only carried lost and other circumstances render dissolution equitable. On the applications of the purchase of a partner's interest under Articles 1813 or 1814. After the termination of this specific or particular undertaking, at any time the partnership was a partnership at will when the interest was assigned or when the charging order was issued. Order of liquidation for a general partnership. Under Article 1839 in setting accounts between the partners after dissolution, the following rules shall be observed subject to any agreement to the contrary. So, the Article 1839 of the Civil Code of the Philippines outlines the rules of dissolving and winding up a partnership. It specifies how the rights and liabilities of partners are determined when a partnership is dissolved. This article ensures that the partnership dissolution follows a legal and fair process, protecting both external creditors and partners. It also prevents disputes over assets distribution. The liabilities of the partnership shall rank in order of payment as follows. First, the owing to creditors other than the partners. Second, those owing the partners others than for capital and profit. Third, those owing the partners in respect of capital. And last, the owing to partners in respect of profits. Next is order of liquidation for a limited partnership. In Article 1861, in setting accounts after dissolution, the liabilities of the partnership shall be entitled to payment in the following order. This article defines agency as a legal relationship where one party or the agent acts on behalf of another or the principal. This agent's authority comes from the consent or authorizations of the principal. This concept is widely used in business transactions, real estate, and legal representation, where an agent is empowered to act for the principal. So, the following order are those to creditors in the order of priority as provided by law, except those limited partners of an account of contributions and the general partners. Those to limited partners in respect to their share of the profits and other compensative by way of income, their contributions. Those to limited partners in respect to the capital of their contributions. Those to general partners other than for capital contributions. Those to general partners in respect to profit, and those to general partners in respect to capital. Next is law on corporation. Section 2. Corporation defined. A corporative as an artificial being created by operation of law, having the right of successive and the power attributes, and properties expressly authorized by law or incident to existence. Next is kinds of corporation. First is stock corporations. One which has a capital divided into shares and is authorized to distribute to the holders of such shares or dividends or allotments of the surplus profits. So, stock corporation is a business entity that has capital stock divided into shares, issues stocks to shareholders who have ownership rights, and operates for profit with earnings and distributed as dividends. Example for that is Jollibee Foods Corporation, SM Prime Holdings, and Ayala Corporation. Next is the non-stock corporations. One where no part of its income is distributions as dividends to its members, trustees, or officers, subject to the provisions of the Code on Dissolution. A corporation is an entity that does not issue shares of stock, exists not for profit but for a specific purpose. Members do not receive dividends. Example for that is the Red Cross Philippines, Philippines Business for Social Progress or BBSP, universities like Ateneo de Manila University or non-stock educational institutions. Next is the corporation de faire. A corporation organized in accordance with the requirement of law. This corporation is a corporation that has been properly incorporated according to law, complies with all legal requirements of the Securities and Exchange Commission, and has a legal personality and protections under corporate laws. Example for that is a company that properly registered with the SEC, secured a certificate of incorporation, and fully complied with all requirements. Next is de facto corporation, a corporation where the existence of law in this incorporation. De facto corporation or corporation in fact but not fully legal. A de facto corporation is an entity that acts of corporation without meeting all legal requirements, may have failed registration procedures but operates as a corporation, still enjoys some legal protections as long as the government does not challenge its existence. Next is the public corporation, one formed or organized for the government of a portions of the state. Public corporation is an entity that is created by the government, performs public services or utilities, transportations, and banking, can be fully government-owned or partially privatized. Example for that is the Bangko Sentral in the Philippines or BSP, the Philippine National Railways or PNR, and Social Security System or SSS. F. Private corporation. One formed for some private purpose, aim, or end. Next is corporate sale. One organized for the purpose of offering and managing as trustee the affairs, property, and temporalities of any religious denomination, sect, or church. Next is eleemosynary corporation. One organized for a charitable purpose. Next is domestic corporation. A corporation formed, organized, and existing under the law of the Philippines. Next is the foreign corporation. A corporation formed, organized, or existing under any laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do businesses in their own country or state. Advantages of a corporate organization. First is strong separate judicial personality. Second, limited liability to investors. Third, free transferability of units of ownership. Fourth, centralized management through the board of directors. Fifth, professionalism. Sixth, easier to sell small amounts of stock to raise a capital. Next is the advantages of a corporate organization. First, extensive government regulation. Second, double taxation. Last is the activities are limited by the charter and various laws. Corporate liquidation. After the dissolution of the corporation, it continues to exist as a body corporate, but only for the purpose of enabling it to settle and close its affairs, but not for the purpose of continuing the business for which it was established. A dissolved corporation cannot extend corporate life during the 3 years liquidation period by the amendment of its articles if incorporation extended corporate term. Conclusion. In conclusion, the law of partnership and corporation is important because it provides rules on how businesses are formed, managed, and dissolved. A partnership is when two or more people share ownership and responsibilities, while a corporation is a separate legal entity that protects owners from personal liability. Understanding the laws help business owners make informed decisions, protecting their rights, and ensure their businesses operate legally and efficiently. And that's it for my report. Thank you.